Daniel Carter believed the stop would end in minutes. A dim street. A minor equipment issue. The officer returned his license, then lingered. One friendly question followed another. Daniel answered out of habit. Each reply widened the stop, stretched the clock, and shifted control. Soon, Daniel stood beside the road while his car sat under scrutiny, adrenaline high, options shrinking. What caught Daniel off guard was how fast everything changed without raised voices or flashing threats. Polite conversation did the work. By the time Daniel realized the encounter had shifted from routine to investigative, the damage was already done. That moment plays out every night across the country. People lose time, money, and leverage because they never learned the words that stop the process cold. This video breaks down those words and explains why they work. If this information matters to you, take a second to like the video and subscribe so you stay prepared before the next stop ever happens. How police encounters are legally structured. Police encounters follow a clear legal framework that determines what officers may do and how long an interaction may last. Courts recognize 3 categories. A consensual encounter allows conversation, yet the driver retains freedom to leave. A temporary detention, often called a traffic stop or Terry stop, permits brief restraint tied directly to a specific purpose. An arrest requires probable cause and triggers additional constitutional protections. During a traffic stop, the officer's authority remains limited to tasks related to the reason for the stop, such as checking identification, running records, and issuing a citation. Once those tasks finish, continued detention requires independent legal grounds. The Supreme Court clarified this boundary in Rodriguez v. United States, 2015, holding that prolonging a traffic stop to pursue unrelated investigation violates the Fourth Amendment. The ruling emphasized time as a constitutional factor, not convenience or curiosity. This framework explains why specific words matter. Courts evaluate encounters based on clear statements and observable conduct. Silence without invocation, casual answers, or vague compliance often extend authority unintentionally. Precise language forces clarity. It requires officers to either articulate lawful grounds or conclude the interaction. Understanding this structure transforms a confusing roadside moment into a defined legal exchange where rights retain real force. Am I free to leave? These 5 words force clarity in moments designed to stay vague. Police encounters rely heavily on time and uncertainty. The longer a person remains present, the greater the chance officers gather observations, statements, or circumstances that expand authority. Many drivers assume a stop continues until the officer chooses to end it. Law treats the situation differently. A traffic stop has a defined mission tied to its original purpose. Once that purpose reaches completion, legal authority to hold the driver ends unless new grounds appear. Am I free to leave? Compels an answer that carries legal weight. If the officer confirms freedom to go, the encounter ends immediately. If the officer says detention continues, that statement triggers a requirement for reasonable suspicion supported by specific facts. Either outcome benefits the driver. Ambiguity disappears. Authority becomes visible. Body cameras capture the exchange, creating a clear record of the officer's choice. Consider a common scenario. A driver receives a citation. Documents return. The officer lingers and asks casual questions. Many people respond politely, believing cooperation speeds things along. Each answer extends the encounter. Time stretches. Observation accumulates. Suspicion grows from conversation rather than conduct. Asking, "Am I free to leave?" stops that progression. It draws a legal boundary around the interaction and places responsibility back on the officer. Courts evaluate police conduct based on objective facts, including whether a reasonable person would feel free to leave. This phrase directly addresses that standard. It converts an unspoken assumption into an explicit question. Officers receive training on this moment. A clear answer limits flexibility. Continued detention without justification risks suppression of evidence later. That reality shapes behavior in real time. Drivers often worry this question sounds confrontational. Tone matters less than content. Calm delivery preserves professionalism while asserting rights. The phrase contains respect without surrender. It signals awareness rather than hostility. Many officers choose release rather than explanation, especially when the original purpose already concluded. Psychologically, this question shifts control. Officers rely on conversational momentum. Once broken, momentum fades. The encounter either ends or transforms into a detention requiring justification. Both outcomes reduce risk for the driver. Silence alone lacks this effect. Politeness alone lacks this effect. Only clarity creates it. The power of these words comes from timing. Ask after the initial mission concludes. Documents returned. Citation issued. Warning given. At that point, authority narrows sharply. Courts recognize that extension for unrelated investigation violates constitutional limits. The question exposes that boundary. Drivers who master this phrase protect time, privacy, and leverage. They reduce phishing expeditions. They avoid self-created suspicion. They preserve later legal challenges if detention continues without grounds. Am I free to leave? Remains the most efficient way to define the encounter and regain control. I plead the fifth. Silence feels protective, yet silence alone carries risk. Courts differentiate between remaining quiet and invoking the Fifth Amendment privilege against self-incrimination. Without verbal invocation, silence may appear ambiguous. Officers document behavior. Prosecutors interpret gaps. Juries infer meaning. Saying, "I plead the fifth," removes ambiguity and activates constitutional protection with precision. The Fifth Amendment shields individuals from compelled self-incrimination. That protection activates fully once invoked clearly. Courts require explicit language. A person must state intent to rely on the privilege. Casual quiet fails to communicate that intent. Officers receive training on this distinction. Pressure follows until invocation occurs. Once spoken, "I plead the fifth" changes the dynamic. Questions lose traction. Continued interrogation risks violation. Statements gathered afterward face suppression. The phrase draws a firm line between voluntary conversation and protected silence. It also creates a clean record on body camera, showing constitutional awareness rather than evasive behavior. Consider a roadside exchange. An officer asks about travel, substances, or activities. The driver pauses and stops answering. Reports later describe nervous silence or refusal. Prosecutors frame that conduct as consciousness of guilt. The jury hears the story through that lens. A simple verbal invocation prevents that framing. It explains the silence before interpretation fills the gap. Effective invocation requires consistency. Once stated, the driver refrains from further answers. Explanations dilute the effect. Additional words reopen conversation. Officers often continue asking questions, hoping for slips. Repeating the invocation maintains protection. The phrase functions like a switch. Flip it once, keep it in place. This principle gained national attention after Salinas versus Texas in 2013. The Supreme Court allowed prosecutors to comment on a suspect's silence during questioning because the Fifth Amendment privilege never received explicit invocation. The ruling clarified a critical rule. Protection requires clear assertion. Practical delivery matters. Speak calmly. Maintain eye contact. Use exact words. "I plead the fifth" or "I invoke my right to remain silent." Both satisfy the requirement. Either communicates intent unmistakably. Avoid filler language. Avoid conditional phrasing. The power of this phrase lies in precision. It transforms silence into a constitutional act. It prevents misinterpretation. It limits narrative manipulation later. Drivers who rely on quiet alone gamble with perception. Drivers who invoke control the record. In legal encounters, the record shapes outcomes. If you find this breakdown useful, hit like and subscribe now, because what comes next protects you even further. I want a lawyer. This phrase ends questioning with finality. The right to counsel stands as a cornerstone of American criminal procedure. Once a person clearly requests an attorney, interrogation must stop. Officers may secure the scene or process logistics, yet questioning tied to evidence gathering ends. Ambiguity weakens this protection. Clarity enforces it. "I want a lawyer" works because it leaves zero room for interpretation. Courts reject conditional language. Statements like, "maybe I should talk to someone," fail to trigger the right. Officers continue questioning lawfully under those conditions. A direct request removes discretion. The moment matters. Early invocation prevents damage before it occurs. Many people wait until pressure builds. By then, statements already exist. Each answer given before invocation remains usable. Prompt use protects immediately. Innocence carries no relevance. Rights apply regardless of guilt or intent. Officers often respond with persuasion. They suggest cooperation helps. They imply requesting counsel signals guilt. These tactics aim to reopen conversation. Repetition preserves protection. "I want a lawyer," spoken again reinforces intent. Tone remains calm. Content stays firm. Traffic stops provide frequent examples. An officer claims odor, suspicion, or inconsistent answers. Questions escalate quickly. A driver tries to explain. Explanations create facts. Facts create probable cause. Invoking counsel halts that progression. It forces reliance on existing evidence rather than self-supplied information. Legally, requesting counsel also strengthens later challenges. Continued questioning after invocation risks suppression of statements. Courts take this seriously. Body camera footage capturing a clear request carries weight. Officers understand this risk and often disengage rather than proceed improperly. Drivers sometimes worry about escalation. In practice, escalation rarely benefits officers without grounds. Detention without questioning limits investigative options. Time pressure favors release. The phrase shifts leverage back toward the driver. Consistency matters again. After invoking, silence follows. Small talk undermines clarity. Even casual remarks reopen dialogue. Treat the phrase as a boundary marker. Once crossed, conversation ends. "I want a lawyer" protects against mistakes under stress. It acknowledges that roadside encounters favor training and experience on one side. Counsel restores balance later in a controlled environment. The phrase buys time. Time preserves options. Options protect outcomes. "I do not consent to searches." Consent stands as the most powerful tool officers use during stops. With consent, searches require no warrant and no probable cause. Evidence discovered becomes admissible. Consent cures defects. Refusal preserves rights. "I do not consent to searches" communicates refusal clearly and respectfully. Many drivers misunderstand consent. Officers phrase requests conversationally. "You mind if I take a look?" sounds informal. Any affirmative response grants permission. Ambiguous replies invite interpretation. Clear refusal avoids confusion. The exact phrase matters. Refusal changes the legal landscape. Officers must rely on independent justification. Probable cause or a warrant becomes necessary. Without those, search authority disappears. Even if a search proceeds anyway, prior refusal preserves grounds for later challenge. Courts examine whether consent existed. A recorded refusal strengthens defense arguments. Tone influences interaction, but fails to replace content. Calm delivery reduces tension while maintaining firmness. The phrase carries no accusation. It states a boundary. Officers hear it often. Training covers this response. Many searches end at that point. Threats follow sometimes. Officers mention dogs, warrants, or delays. Each option carries legal requirements. Drug dogs require reasonable suspicion and time limits. Warrants require probable cause and judicial approval. Refusal forces adherence to those standards. Conversation alone no longer supplies shortcuts. Importantly, refusal requires repetition if pressure continues. Officers may rephrase requests. Consistency prevents erosion. "I do not consent to searches" spoken again reinforces the boundary. Physical resistance remains inappropriate. Verbal refusal suffices. Drivers benefit even when searches occur despite refusal. Evidence discovered faces scrutiny. Courts assess whether probable cause existed independent of refusal. Many cases hinge on this distinction. Without refusal, that argument fades. With refusal, it stands. This phrase protects privacy and property. It also protects dignity. Roadside searches feel invasive. Refusal asserts autonomy within the law. Respectful assertion preserves safety while defending rights. Mastery of this phrase completes the set. Combined with the others, it limits exposure, controls duration, and preserves legal remedies. Each phrase covers a different risk. Together, they form a comprehensive defense against overreach during traffic encounters. Physical protocol during a traffic stop. When emergency lights activate, behavior matters as much as words. The goal stays safety, clarity, and control. Pull over promptly in a visible area. Reduce speed smoothly. Sudden movements raise concern. Once stopped, turn off the engine and keep both hands visible on the steering wheel. At night, activate the interior light so movements remain clear on camera and to the officer's eyes. Lower the window a few inches rather than fully. This allows communication while preserving personal space. Keep doors closed. Before reaching for documents, speak first. Say where the license or registration sits and wait for acknowledgement. Slow, narrated movements reduce misunderstanding. Officers receive training to watch hands closely, so transparency lowers tension. Remain seated unless given a lawful order to exit. If asked rather than ordered, clarification helps. Calmly ask whether the request carries an order. If an order follows, comply while maintaining visible hands. Compliance paired with verbal boundaries preserves safety and legal position together. Voice tone stays steady and respectful. Emotional spikes escalate encounters. Short responses carry strength. Long explanations invite misinterpretation. Body cameras capture everything, including posture and pacing. A composed presence communicates confidence and awareness. Physical resistance never helps. Verbal assertion remains the proper channel. If a search or action proceeds despite objection, continue stating boundaries verbally without interfering. Courts review conduct later through recordings and reports. Clean behavior strengthens credibility. This protocol balances cooperation with self-protection. It signals awareness without confrontation. Officers tend to respond better when interactions remain predictable and calm. Mastering physical conduct prevents misunderstandings and supports every legal phrase used during the encounter. Common mistakes that destroy legal protection. The first mistake involves excessive talking. Permission out of discomfort costs rights. Firm language delivered calmly maintains courtesy without concession. Confidence and respect coexist easily. Fifth, many answer one final question after invoking rights. That single reply reopens dialogue and creates usable evidence. Invocation requires discipline. Once stated, conversation ends. Officers may continue speaking. The driver remains silent. Immediately. Body cameras record posture, pacing, and demeanor. Aggressive gestures or sarcastic remarks shape narratives. Calm conduct supports credibility. Avoiding these mistakes preserves every advantage. Rights depend on action,